to recording this seconds. Greet the audience, and we will then move to the our guest speakers from the Euro Commission and the IP Help Desk.
Okay. Thank you, Shorena, and thank you, dear guests and participants, that you take part in this event. I would like to thank our guests for their time and effort for these presentations. And let's begin. Thank you, everyone.
Okay, I hope you can see our agenda. As you know, we have our guest speakers, our experienced guest speakers from the Euro Commission and the IP Help Desk. So it's Federica Baldan and Michel Dubini. As far as I know, the Federica will start, and then Michel will continue. I hope I'm pronouncing the names correctly.
So thank you very much.
Thank you.
Thank you for your kind introduction. Can I share then my screen with the PowerPoint?
I will stop sharing, yes, and you can. Now you can.
Okay. Can you see it? Can you see the presentation?
Yes, we can see.
Perfect. Okay, so thank you very much. I'm here as a representative of my unit that deals with valorization policies and intellectual property rights as part of the Director General for Research and Innovation. I am a legal and policy officer, and I joined that unit about 2 years ago. My purpose is to briefly present the policy context and the issuance of the Commission recommendation on the Code of Practice on the Management of Intellectual Assets. So concerning the policy context, I will start by...
Just one issue, excuse me. Could you switch to the Shorena to the presentation mode, because I think we are watching at the with the slides at this point. Yeah, something like that.
Is this better?
Not yet. Maybe the bigger. This screen next to it.
Federica, display settings, up above?
Yeah, because I can only see it from one.
Swap?
And yeah.
Perfect.
Perfect. Thank you very much, Michael.
Thanks, everyone.
Thank you. I will start the presentation by providing the key definitions for the policy context. One of them relates to knowledge valorization. Knowledge valorization is the process of creating social and economic value from knowledge by linking different areas and sectors and transforming data and research results into sustainable products and solutions that benefit society. So we do not look at the results of our R&I activities only from the perspective of what is the financial return, but rather what is the societal impact from the perspective of economic prosperity, environmental benefits, societal progress, and better policy making. One of the main channels for knowledge valorization has been identified in intellectual assets. So intellectual assets do not just include intellectual property, so the assets that can be protected, legally protected, or can be owned in a legal sense, but all the various results of our R&I activities. So not only patents, copyrights, and trademarks, but also data, know-how, prototypes, processes, practices are part of this wider understanding of intellectual assets. This responds to the more advanced, let's say, ecosystem, RNA ecosystem, where indeed we can extract value from a variety of results. Our policy initiatives are placed in an RNA landscape where similar initiatives have been taken. For instance, at the level of WIPO, so at the international level, also guidance has been provided for the management of intellectual property rights. There has been an issuance of an IP toolkit to help universities and research institutions dealing with the management of their intellectual property, and also guidelines. So for more concrete hands-on recommendations have been delivered. We had also guidance at the European level since 2008. We had a code of practice for universities and public research organizations for the management of intellectual property. But there has been through the policy dialogue of member states, it has been stressed how the RNA landscape and the overall ecosystem has changed since 2008, both from the perspective of the actors which are involved. So we do not only have the universities and public research organizations, which are part of this ecosystem and have an important role in generating results, but we have, for instance, companies, SMEs, investors, individual researchers in their group, policymakers, society. So this has to be taken into account, and this is the first big change that we have in our policy initiatives. The second big change is, as I already mentioned, that we look at intellectual assets more in general and not just at intellectual property. So how did we translate these changes? The Commission proposed a recommendation for guiding principles for knowledge valorization, which has been adopted by the Council, so representatives of the Member States, in December 2022. And that responds to the needs and the feedback of knowledge valorization actors, including policymaking, and provides also a common reference to improve knowledge valorization in the EU. So the guiding principles are addressed to policymakers, governments, and the Commission. But what was also asked by member states was to have a more hands-on guidance for practitioners. And that's why the Commission has adopted codes of practice, one code of practice on the management of intellectual assets and one on standardization. And these were adopted in March 2023, so almost 1 year ago. There will be other two codes adopted in a matter of days. One is to provide guidance on industry academia co-creation, and the other one relates to citizen engagement for knowledge valorization. So let's focus on the code now. The objectives of the code are to increase, obviously, the use of research results in order to respond to the challenges in the economy, in the society, in the policy. So we are trying to to act faster and better to turn our knowledge and the results into value for the society. We, with the code, aim to accelerate the uptake of innovative products, services, and technologies, and provide a strategy for efficient management of intellectual assets, as well as recommendations for tools and contract conditions for cooperation, and other aspects related to monitoring results, protecting IP, sharing, licensing, and disseminate are all covered by the code. So this is an overview of the content of the code. The code is structured in 3 main chapters. The first one relates indeed to the strategy And the main addressees are organizations. So for instance, universities, public research institutions, but recommendations can also be addressed to researchers, for instance, and their teams. Then we have a chapter that relates to the management of intellectual assets in joint research activities, and a chapter that relates to the path from intellectual assets creation to the market. So the recommendations really try to cover the entire path from the beginning, so creation of a strategy until the market uptake. And within each chapter, as you can see, there are different sub-chapters, one more defining the strategic practices for intellectual assets management, one which relates to the sometimes controversial relationship of intellectual assets management and protection with open science and open innovation, and one that focuses more on education, training, and awareness raising. In the second chapter, we have provisions really that aim to help in the management of assets for joint collaborations. So for instance, who owns what, how should the results be exploited, what are the collaboration conditions that should be included in into these joint research activities. And then finally, the last chapter deals with finding what is the best mean for controlling the assets, then aspects related to valuation of intellectual property, monitoring, transferring, and licensing practices. So what could be of your interest relates to indeed the aspects of the code in joint collaborations maybe. So I extracted some key elements for this presentation from each chapter, and then I have a slide that focuses a little bit more on open science aspects. So concerning the very first chapter on the strategy, for instance, what the code recommends is that the strategy encompasses creation, management, and utilization of all types of intellectual assets. So it is valuable to think beforehand about not just about patents, as maybe it was a rational for the previous type of or the previous RNI environment, but to all the assets that might be generated through RNI activities. Then the strategy should also take into account possible conflicts of interest and joint ownership situations. Due diligence is also one of the aspects that should be considered. And also, the strategy should include some elements which relate to a fair and equitable sharing of the value which is generated in RNI activities. Considering the impact of the value, considering also the contribution. So for instance, in the case of collaboration between industry and academia, if industry is bringing background IP, for instance, in the collaboration, how should then the value be shared from the results of the RNI collaboration? Should this be should this take into account the different contribution by academia and the industry in the collaboration? Then another important aspect to include in the strategy concerns open science and open innovation. So as you might know, open science is one of the main policy principles in Horizon Europe. So it's a very important aspect to take into account and to consider also in relationship to protection of intellectual assets. And then it's also important to invest in education, training, and awareness raising, and this should be embedded in the strategy of an organization. So, for instance, including courses for researchers on intellectual assets management, raising awareness on the fact that international collaborations can happen with countries that have a different framework for protection or exploitation of intellectual property, and so on. So as I mentioned, I included a short slide that focuses more on open science and open innovation. So open science is the approach to the scientific process based on open cooperative work, tools, and diffusing knowledge. And this can be combined with open innovation practices, so opening up the innovation process also for actors and activities outside of an organization. And what is important to consider in open science and open innovation relates, for instance, to a publication and exploitation strategy. So what are the clauses in funding, in collaboration, in transfer and licensing agreement? Are there any legal constraints, terms, and conditions of dataset and legitimate interest considerations? What are the repositories that I would like to use to share my findings? Are these to be trusted? Moreover, for open innovation, you can use different types of platforms and pre-competitive partnerships, and this might include also fair and flexible sharing and compensation models. So these are all different considerations that can be taken into account and actually are recommended to be taken into account by the code at the level of the strategy of the organization. In the second chapter, these are also some key elements that relate to joint R&I activities. So one first important aspect is clarifying ownership of intellectual assets as early as possible. And this entails mapping the various assets. So before the start of the project, preparing a list with the background results. So who owns what, for instance? I mentioned an example before of industry-academia collaboration in which industry or academia comes with the background IP. That should be an element taken into account from the beginning of the project in order then to consider if further results are built on this background IP, how do we deal with the exploitation of them? During the project, it is also important to update this list and keep track of results generated and who is the owner. And then at the end of the project, preparing a results ownership list. So for the ones who are familiar with Horizon Europe, that's also part of provisions in the framework now. And it is very important to identify indeed all the results, who owns what, and how can they be exploited. There are also some recommendations that target specifically publicly funded research. And here I indicated one of them, where it is recommended that in industry-academia collaboration, the ownership of the results is granted to the research organization and access rights are given to the industry participant. But this obviously needs to be nuanced and shaped, considering also the particular conditions and elements for the partnership. So another important aspect is establishing clear collaboration conditions. For instance, as I mentioned before, with a revenue share agreement. So thinking if there is a joint activity, how the royalties, for instance, are going to be shared between the participants. When participating in these collaborations, it is also key to think what I want to share and what I don't want to share, what I feel comfortable in sharing or not, and maybe considering also signing a non-disclosure agreements, in particular if the results that I'm sharing are not protected. And also considering trade secrets protection. What is useful is that there are already existing toolkits, for instance, in the shape of model agreements that provide some clauses, some examples of clauses to be included in collaboration agreements. So that's a very important element to set the collaboration. And another aspect that I briefly mentioned before is also important to consider differences in legal framework with for collaboration with partners from different countries. So in Europe, more or less, there is harmonization, for instance, from the patent perspective with the European Patent Convention, from the trademark perspective through EU legislation. But for instance, if we have an Eastern European country, a country from the eastern part of the world and from the western part of the world with very different legal frameworks, it is useful to think beforehand if there is a dispute, where we're going to have this dispute, what should be the best framework for dispute resolution. And finally, the last chapter of the code relates to bringing the assets to the market. And there, it is important to think about what are the most suitable means for the control. So preparing, for instance, a freedom to operate analysis in order to make sure that I'm not infringing IP rights of others. I'm not really going into the territory of other assets which are protected. It is also important to invest in the necessary skills and profiles internally, if possible. So, for instance, having IP law specialists helping with looking at the possibility, for instance, of protecting some intellectual assets and understanding the different provisions in foreign markets. Another important aspect concerns valuation of intellectual property, and what is important and is recommended is in particular to define what are the targets for this valuation. So organizational, cultural, economic, environmental, and social value. And also make sure that there is a common approach in case there are joint results for the valuation. It is also recommended to adopt an open, transparent, and non-discriminatory approach, and there are also recommendations with respect to the methodology for IP valuation. The aspect of monetary transfer and licensing is also considered, and recommendations are included with respect, for instance, to identify who are the stakeholders that could be involved in the dissemination and exploitation of the results. Also thinking if it is possible to engage in collaborative license mechanisms. So is it possible to share results through a patent pool, a clearing house that would facilitate, for instance, cross-licensing. So it is important to see, especially when considering a particular sector, if there is some kind of instrument out there that could facilitate the exploitation of the results. And also, especially important for public research institutions, if it is possible to license by committing to socially responsible licensing practices. So not just take into account what could be the economic return, but also trying to license the results, considering other important values for the society. So this was a quick overview of some elements of the code of practice. I included some links with more information and stressing also that there will be the 2 new codes that I mentioned on industry, academia, and citizen engagement published soon. And I stop sharing now, and I thank you very much for your attention. And I'm sure that some of these aspects will be explained better by Michele in the following presentation. Thank you.
Thank you very much, Federica. It was very interesting and insightful presentation. And I recommend the audience to write questions in the chat or keep it for the end because we will have the Q&A session at the end of our info session in order to to keep it for the end of the day. And now, yeah, Michele can speak. I hand over to him to start his presentation.
Thank you. Thank you very much, Serena. Thank you very much also for the invitation, and I'm going now to share my screen. Can you see it? Yes. Now full screen it should be. Can you confirm you see it full screen, or is it the presenter mode?
It's not full screen.
Okay. What about now?
Not yet.
Not yet.
Not yet. Mm.
Wait a second. This is strange. But you can see the screen, right?
Yes.
But you see it.
I use down the.
Maybe only the window is shared, and that's why it's not showing.
Okay.
1 second then. Okay. So now it should be working.
Yeah, but it's again like Federica's
Okay.
presentation.
Now we made it.
Yeah, now it's perfect.
Sorry for the short delay. Thank you again. And so my name is Michele Dubini, and I am part of the European IP Help Desk training team. I'm a lawyer. I'm specializing in IP law. And what we do within the European IP Help Desk is try to bring about intellectual property to small and medium enterprises, researchers, anyway, all those subjects that might need a first-hand support regarding intellectual property and intellectual property rights, but are not yet, for example, in the phase of protection, registration, and so on and so forth. And we especially focus, given the target audience that we have, on Horizon Europe now. When I started, it was still FP7, so not called Horizon yet, and it was a couple of years ago, Horizon 2020. We're going to focus today on Horizon Europe, but I wanted also to mention that the European IP Help Desk is helping free of charge with a first-hand advice, small and medium enterprises, researchers, so all physical and juridical persons who would like to have more information regarding intellectual property and intellectual property rights. So through our website, you can have access to different services, like, for example, the trainings that we offer. I show them very briefly later on, and publications as well are available to download free of charge. There is also a helpline which you can contact. You can type your questions and they will answer within 3 working days. This is quite useful because it's like you'd like to receive a first idea of what you are thinking and whether you might have to contact, for example, a patent attorney or not, and that could be a good way to do it. I think today it might be interesting also to talk about the boundaries of the service, because we are called the European IP Help Desk, so of course we cover all the boundaries of the European Union. However, also associated countries to Horizon Europe are eligible to receive the services. So I'm talking about Norway, Switzerland, and many other countries. And I think from 2021, Georgia is one of them as well. So all the services that we offer, and I have explained to you before, are perfectly eligible for Georgian small and medium enterprises, but also researchers or even juridical and physical persons. These are the info that can be downloaded a little bit from our website. There is much more, of course, up there. And we also organized trainings on a semester basis, and we're going to be starting actually at the beginning of March. So if you'd like, also the trainings are completely free of charge. And for example, on the 9th of April, I'm going to give a full presentation of intellectual property in Horizon projects, which means that what we are going to be discussing today, or not in these 15-20 minutes, is going to be much more focused and analyzed in detail in a 1 hour long, 1 hour and a half long webinar. In fact, today I'm going to focus on a few topics that Shorena has very kindly hinted to me before this meeting that we are about to have. But as you will see, they really have a lot to do with what Federica has already anticipated. Actually, she has said basically everything that you need to know, of course, from the European Commission side. But I'd like perhaps to bring you a couple of experiences, a couple of cases that we've had throughout the years, and what we've seen have been main problems for small and medium enterprises or researchers that were part of FP7, Horizon Europe, and Horizon 2020. Of course, one main problem is the safeguard of ideas. Sharing is the base of a Horizon Europe project. However, of the project itself, not before the project has started. And it's important to keep that in mind, because once the project has started, we've got the protection of the consortium agreement, confidentiality measures that are in there, even within the grant agreements, confidentiality towards the European Commission, for example, but also towards the other parties. But the point is that when we bring ourselves together around the table to write down our proposal, we have no such confidential disposition already in place. And that might be a problem in the case, which is unfortunately not very unlikely, that our proposal is not going to be financed. Because at that point, everyone can walk away with the information without even blink their eyes and use them for their own purposes. I remember when I started in FP7, nobody was taking these measures in order to ensure confidentiality even before project had started. But now the situation is reversing, in the sense that many more coordinators are doing this, many more partners are requiring this. And this works in both ways, in the sense that you should perhaps think about this, but you don't have to be scared if, for example, in the preparation of the proposal, you are asked to sign a non-disclosure agreement, such an agreement, because it is in your interest, but it is also in the interest of the consortium itself. One most frequently asked question that instead we receive is regarding open science and protection. We're going to see in the next few slides that the European Commission is giving the consortium a couple of obligations. Among them, there is the obligation to protect on one hand, and the obligation to disseminate. This is for let's say subjects that are at their first experience within Horizon Europe quite confusing. And the first reaction that we normally receive is that how can we protect results while we need to disseminate them and ensure that this dissemination is done through open access means? I'm going to try to give an answer to that. So all this is to provide a couple of general information regarding intellectual property management, and I will add some of them here and there. Starting before the project start, I have introduced this already. So we meet, we gather, and we need to talk about how we are going to put this thing together and request, so write down our proposal. First thing that we need to do is to define the state of the art. which means that we need to understand where we are and where we want to arrive. The state of the art can be also information that we provide, information that might be, for example, not available to others and will be available throughout the proposal writing. That, as I said before, can be tricky in the sense that there are no confidential information in place, and we are giving these information to institutions that might be very far away from us. They might be in Europe, but also Canada now is an associated country, so it can be really in different continents than ours. And so the background is definitely important, but it becomes background only when we have started the project. Before, it is just information, and as such, can be then shared, but it's going to be used by somebody else potentially. So that there's going to be then patents also, and if we have them as a basis, we basically don't have any form of risk because they are already protected. But that, I would say, in my experience, patents in projects in the background at the beginning of the project, they are the 1, 2, maybe 3% of the overall information of a project. So very, very small part that it is protected in any case. And the main part instead is simply information that can be confidential. As European IP Help Desk, for a few years now, in order to let's say facilitate this exchange of information, we make confidentiality agreements available. They can be one-sided confidentiality agreement or two-sided confidentiality agreements, which means that with the first, one side is obliged to enforce confidentiality, and so request the permission to share the information and so on and so forth. With the second, which is more fair, to be honest, and that is something, maybe the only thing you need to check when you receive these kind of document, is that both parties are bound in the same way. So that basically I cannot share information that I receive from you, and you cannot share information that you receive from me. Just here, there is one funny thing. It happened to me only once, and it was very unfortunate. Beware of third parties IPR infringement. And the acronym. Once one project had chosen a acronym that was basically infringing a trademark. It's really, really rare, but if you simply check 3 minutes on UIPO's trademark view, you're going to see whether, for example, your trademark, your acronym is already a trademark, and then perhaps change a couple of letters in it. And then when then you will arrive at the consortium agreement, you need to pay special attention to the attachment 1 of the consortium agreement, your part, but the part of the others as well, because the attachment 1 is the part of the agreement in which the background information is enshrined, where it is written down. And so you need to make sure that somebody taking a look at your background is going to be able to see what they might be needing from you, and actually all the information are in there, but you also can use it as a form of checking whether other participants are then providing all the information that you are going to be needed in order to carry out the project activities. So very, very important, important document. And I have to say, in our experience, in very few cases, this is filled in properly. Some information are missing, some other information are only partially inserted. And so the suggestion here is to pay very much attention on the attachment 1. This is regarding all the activities that come before the project has even started. And when we are in that limbo in which We still don't have the confidentiality protection of the consortium agreement, but we need to share information. Once we have the consortium agreement, and so we have done the attachment 1, and we have brought inside our background, we show that we are the one bringing in such form of information, then we have, under the intellectual property point of view, much less to be worried about. The point is that we will have a consortium agreement only if the project is financed, and the vast minority of projects in Horizon Europe, Horizon 2020 are actually financed once the proposal has been written down. Now, regarding the second point, instead, I think Federica has very well described the principle of open data, open access, but also open innovation. And I will simply skip it in order to introduce instead what are the obligations that are connected to that. On one hand, the European Commission is telling us that we have the obligation to disseminate the results, but the grant agreement is telling us we need to disseminate as swiftly as possible, which means that actually the grant agreement is telling us to check whether what I have could be patentable or protectable before disseminating. And if that is the case, to start with protection activities and carry out the general obligation to protect. And that is why there are some measures in place in the consortium agreement that can help us deciding what to do with the dissemination and the timing in which we are going to be doing that. And if you read, if you are already in a project, you can read your consortium agreement. It is in section 10, and you'll see that there is a certain amount of days given before you can disseminate the results, before dissemination activities may start. And these days are to be counted after you have communicated to the other parties in the consortium your intention of disseminating. This is to allow everyone within the consortium to start with potential protection activities. And this is very important because in many cases, if you disseminate and so you publish before protecting, and so for example, filing a patent, then you will not be able to file after you have already disseminated. And this is a situation that could create problems to the exploitation activities, to the use of the results in the future. And so the European Commission wants to put all the measures in place in order to avoid that potential unpleasant situation. And then we go with the general obligation to protect. The European Commission is telling us you need to protect your results, but only if the protection is possible and justified. So what does possible mean? Well, not everything is protectable. If you check the European Patent Convention, you'll see that ideas per se are not patentable because we cannot take away an idea for ourselves and not allow anyone to use it. So, for example, inventions are protectable, industrial designs are protectable. Also, let's say signs in the market are protectable, but a general concept like an idea or a theory, for example, cannot be protected. And regarding the justification, we choose to protect based on the goal that we have. So protection is justified, for example, if my goal is to go and commercialize my invention in the market. And so I need that advantage position in order to do that. And so it's right for me, that's the right strategy to protect. But for example, if I create a open source software that I would like everyone to be able to use, and I simply want all the community to be able to build upon it and use it along, which is possible given the characteristics of the code. It does not necessarily, it is not necessarily excluded. Well, then it can very well be the case that a patent in that case is simply not needed, or if we want it, we can patent and then allow everyone to have a free license for the use. But this is to make you understand that depending on the goal that we have, the justification to protect might be there or might not. It depends on what we want to do. And this justification is very much connected with the question that I was bringing in at the beginning of the presentation, that some beneficiaries come to us and say, how is it possible that I have to publish open access? I have to provide all the information on online servers to everyone who's interested, but you tell me that I also have to protect. This does not make sense to me. But that is actually how, for example, the patent system works if you think about it, because you file a patent, and at the same time, your abstract and the requirements are published on the eSpaceNet website, maybe 1 year later, but still they are published. And so like this, you are actually sharing all the information regarding your invention online with third parties, with whoever is interested, but you are restricting the use of these info to those parties that are now able to know but not to do. And that is exactly the let's say the small part of the reasoning that miss the knowledge of the beneficiaries that asked this question. In fact, that open access and protection are completely can coexist perfectly, in the sense that in many cases protection is just a way to share the knowledge but to restrict the use. And this confusion between use and knowledge is what we try to make understand with our answers, with our webinars, and with our trainings to all participants. And if there are questions regarding this, I'm very happy to answer them. Also, I was saying is protectable. This is just for your knowledge that only some intellectual property rights can cover some other form of intellectual property, but not everything. And then Federica was introducing the fact that you basically need to manage intellectual property and intellectual property rights. I chose this example regarding this because this is something you'll always have to deal with in Horizon Europe, given the nature itself of the programs and the projects in which you're going to find yourself in, or in which you are in. We are into a collaborative research environment, which means that everyone is bringing the background, as we saw before, in this machine, which is a project, and results are going to be ejected, so to say. But given that we have put together our time, resources, and effort in order to create these results, well then, we are going to be rewarded with the ownership of the different results together, because we are the ones who contributed to the generation together. And what has been done in many projects that I've seen in the past is a joint ownership agreement, which means that the consortium agreement normally foresees the chance of drafting a joint ownership agreement for the parties within a certain amount of time. And in that joint ownership agreement, as Federica was introducing before, that share of ownership, that share of cooperation, and also the use of the results, potential licenses that we might want to have or might want to give to third parties, is actually written down. This is very useful for the usage of the results, because it becomes, let's say, a first step towards the use. Say, put everything in its place under a theoretical point of view, in order to be able to do that really in the market. And at the same time, it's a way to avoid potential attritions within the consortium, because we still have to work together. Unfortunately, we do not have a template for a joint ownership agreement, like I have showed you the non-disclosure agreements before. However, we have a fact sheet regarding that, and where we can say, look, if you're drafting this, you should have at least the points that you can see here: the identification of the joint owners, the allocation of shares, also because, and that is interesting, I connect myself once again to the speech of Federica before, the allocation of shares that you're going to be doing of specific results in the joint ownership agreement becomes even more interesting in Horizon Europe in respect to Horizon 2020, because of the allocation of shares that you can do, if you want, in the joint ownership agreement, which is going to be very useful at the end of the project for the results ownership list, which is a requirement, as we have seen before, that the European Commission is asking to all projects now, that before the project is over, we can provide a specific list with the split, so to say, of the shares, or let's say the different results to who they belong. And then there might be the condition for non-commercial use and the condition for commercial use. This is a very interesting topic as well, because let's say, for example, let's say, take an example, Marie Skłodowska reaction projects as an example. We are always going to have in there academic partners, but at the same time, there's going to be big companies working in the same consortium. So the latter is probably going to be interested in the use of the results commercially within the market. But the academics, the university, is certainly, or very much likely, not going to be interested in that. So a good solution for the share is to simply divide their use. So divide, for example, the property in 50-50, but then divide the use in non-commercial for the university and commercial for the company. Everybody is happy, and everybody can do whatever they want with the results generated. Rules on the license, whether license is possible, sub-license, whether that is possible to third parties, which third parties, and also pay attention to the transfers, because there is a special rules in the grant agreement that says that all transfers of results, or also exclusive licenses that are done outside the European Union, must be communicated to the European Commission, and they have to be validated, so to say. So being Georgia outside the European Union, that's basically the only difference that we have through EU states that can be, let's say, if you do not know it, a little bit challenging, but it's really not the end of the world. Protection and maintenance, monitoring and enforcement, how you plan to do this, and the governing law and jurisdiction. So also Federica talked about this before. Normally what we see, just to give you a benchmark for reference, all consortium agreements and all joint ownership agreements have a governing law and jurisdiction, Belgian law, and Brussels courts, because that is basically the intersection points between all parties involved. But nothing prevents you, for specific results that you're very interested into, to at least propose to have Georgian law or Georgian jurisdiction. There is absolutely no point against this in the grant agreement. I talked about the results ownership list. Very interestingly, if you keep your attention high in the next upcoming month, we are going to have the first examples of results ownership lists, because chronologically, the first Horizon Europe projects are going to be ending in the next upcoming month, and they will be required to give the results ownership list at the end of the project. It could be that we can have a couple of examples of these right in the nearest future, which is, of course, very much welcome for those that in 1 or 2 years will have to do the same thing. Yes, that's basically it. And like I usually do, I went out of time. I apologize for this, but if there are questions, I'm very happy to answer them.
Thank you, Mikael. It was very thank you for providing practical insight related to intellectual property rights. And there are questions in the chat. Do you want me to read it out, or how should we proceed?
Yes, I think I can see them. I can see them. Oh, it's Claire. Claire, yes, she's my colleague, and Givi, she has come back yesterday because she had a baby. So it's a very nice event. But if you write her, she's going to answer tomorrow. We already have a patent, VIPO. Although the time has passed for patenting in other countries, we only managed to accept a patent in India. We did not have any more funds. Now we are ready to file an improved patent to resume international priority and obtain a patent in country interested in our innovative achievement. Please confirm that this will not interfere with applying for Horizon. It will not, definitely not. Actually, as soon as you will have that patent, and even if you have the patent application at WIPO, you should mention it in the proposal as first of all, to create that state of the art that I was talking to you about, the benchmark to be surpassed. So in order to tell the commission or the evaluators how you will do better and improve in that technology, you take an example, the previous patent that you had filed, even if it's not filed in Europe, in Germany, in France, but just to give a technical document that expresses technical information. And then you explain how you will improve that and how you will protect that improvement in the future. But do not be worried about the fact that you have a patent for an application. It's a plus, never a minus. And then question number 2, it's in the first presentation, so I would leave it to Federica. The question, maybe I can read it to you, Federica, if you want. You're muted.
Yeah. So thank you very much for your tips in the first presentation on what logic we should use to advance the project. Based on the same logic, we want to assure you that we have already passed this path and we are following in the future to transfer knowledge to new generation and institutions involved in research work to introduce innovation. Can you please recommend how we can do the same with foreign research institutes? I think this question maybe is more for you, Michele, than for me. It's about international collaborations.
Sorry, I just read first presentation and I thought it was for you, but I'm gonna take it over. So let's say now, because I always think about foreign research institutes, but from the inside of the European Union. But we need probably to turn around this question because it's actually coming. So when we say foreign, we are here also taking into consideration even European research centers inside the European Union. I can tell you, unfortunately, that it is not always easy. And my example is about, unfortunately, consortium agreement negotiation. I have been involved in 70, 80 of them in the last 10 years, and it is not, to use an euphemism, always pleasant. It's quite unpleasant in the vast majority of the cases, especially when foreign institutes in some cases are compliant, in some other cases not. Some countries are better, some countries are worse. For example, normally the United States, the Netherlands, Germany are a little harder to deal with. The United States, because they have um, a completely different environment and legal background, and other European countries because they are quite strict, so to say. My recommendation is to have patience, and if you are in the round of negotiation of the consortium agreement, do not expect that at the first attempt you're going to have it. That is never going to happen. I can tell you, in my experience, we have the second, the third, the fourth, the fifth round of negotiation in order to find a possible solution, and translated into timeline that is from 1 to 3 months also. So my first advice would be patience for this. And the second advice is flexibility, so that basically you can accept some terms given by other parties within the consortium, and then maybe request some more flexibility also from their side. But it's simply a negotiation, and it's like negotiation in many other things. It works like that. I hope I've answered to the question. If I haven't, you can bring up another one. Number 3, we are ready and already in the process of collaborating with Canadian manufacturers of the same but old technology. So I suppose this refers to question 1, but let's read it completely. We wish and are looking for channel of cooperation for European manufacturers. Apart from direct attempts to find interested parties, can you recommend other ways to establish cooperation? Maybe I'm saying something wrong here. Correct me, Shurena, or also the other organizer if I'm wrong. With the Enterprise Europe network, would that be a viable path for a Georgian company? Of that, I'm not really informed.
Yeah, as far as I know, Georgia was going to join EN. I'm not sure because we have the Anna Goletiani, who is the NCP for the Innovative Europe, and she's more aware of this, but she's now abroad, and I think she's not here.
I can partially answer. I was also involved with Anna
Mhm.
in those discussions. We were part of EN in the last round, but the application has not been renewed, I think, or something like that. So we are
Okay.
in process now of renewing the application, but we will be joining well in some period for sure.
Yeah, I mentioned this as a first option because, of course, the main goal of the EN is to connect companies around the European Union and the associated countries. So that would be a very great way. Then there are some more subtle way, I would say, to find potential partners and cooperators across different countries or continents in some cases. And it is through the use of, in this case, patent information. Because something I did not say in the presentation because of the restraints of time is that we do not need or must think about patent and intellectual property right only as a passive blockers for third parties that allow us to exclude others from the use of the results and protect what we have generated, but they can also be used actively in order to find who is doing what in the very same field. In fact, if we have a protected technology, we can use our abstract in order to search for keywords in the very similar field to ours. And in SpaceNet, we basically have 80 billion documents, and some of them will belong to potential companies across, for example, European Union states that has filed or has anyway been active in the very same field as our invention. And therefore, that can be a potential manufacturer or let's say cooperator in the field. So this introduces a completely different field, let's say, or also topic, which is the active use of intellectual property rights. But if you search on SpaceNet using your patent or your technology and see what are the connected technology, you very well might be able to find some manufacturers operating in that very same field. That is a more subtle question. More direct, I would tell you directly EN. That's it. Our innovation has the nature of the entire range of challenges that you mentioned in the first presentation. We are ready to issue licenses to interested parties. In addition to legal assistance, can you recommend how to get financial support to pay for such legal services? I'll take over the question, Federica, if you have nothing against, and if you want, you can add some info then. It's true. So basically, the European IP Help Desk, we stopped at the information that we provide. We do not, for example, as I was mentioning before, file patents or trademarks or other intellectual property for the for the beneficiaries. However, there is other form of supports, for example, from the European Union Intellectual Property Office with regard to small and medium enterprise funds and help that that can be given. For example, one example of this is the SME fund that can provide reimbursements of costs for filing within the European Patent Convention or within the European Union for trademarks or industrial design. There is also the SME booster, which is a way for small and medium enterprises to get financed and to protect intellectual property and also use the funds to exploit their results. The only thing that it's my fault, I didn't check it before coming here today. If it's also available for companies, for Georgian companies. I'm not sure about that. I apologize for this. I will check it, and I will maybe I'll write it to you, Sharena, if I didn't think about it. It was a very possible question, to be honest. I should have checked it before, but keep in mind that you can also perhaps check it out for yourself, the SME fund and the IP booster.
Okay, thank you, Mikael. I will then share this information later and provide it. Raised hand. So this Mr. Mikhail Chikradze has a question. Please go ahead.
Good afternoon, good evening. I'm Mikhail Chikradze, representing the Georgian Technical University. I would like to thank the organizers and the experts for the nice event, which is very important for scientists, especially. And thank you for this a nice meeting for sharing the information. I have only one question. This deals with the intellectual property assets management part. If we have local Georgian patent, and we have interested parties from Europe, for example, from France industry, what are the necessary steps to make the technology transfer, or some kind of the relevant steps if our technology is relevant to, for example, RTL technology readiness level of 4 or 5? What is other recommendations, because we don't have international patent right now? And how can we manage our local Georgian patent in order to go forward without any unclear cases, which we have less experience as a scientist? Thank you very much. This is the only question.
Thank you, Mikhaili. And so as just to make a context also for everybody else, Mikhaili knows it already, but intellectual property rights, in this case the patents, are territorial rights. That means that the Georgian patent that the company has cannot be enforced in the European Union or in France in this case, which means that potentially the French company interested in the technology could simply take it and use it in French territory. However, very often behind patents, so behind what is written inside the document in itself, there is, and maybe you can tell me if that could be the case, Mikhaili, a large environment constituted by know-how. For example, there is a method for doing something that is described and protected through the patent, but the skilled labor that can do that is part of the resources of one company, and it is not available for the other company, which means that theoretically the knowledge can be transferred by that, but the actual implementation still cannot. And so what we see in patent transfer, intellectual property transfer, is that very often, beside the paper in itself of the patent, which can or cannot be protected, there is some form of sensible information that we could call trade secret in many cases, that can still be licensed because it is needed in order to run the patent or the production in itself. So what you could do is, okay, my patent is not enforceable in the European Union, but I'm very good at doing what I do, and so I could perhaps teach you how to use that patent if you're not able to do that. And you could license out that knowledge that you have instead of the patent in itself. Now, please tell me, Mikhaili, if that could be a case, or we can even go more deep in the discussion of this.
Actually, it's this indication that these hints give us very useful information. We have to think about, analyze. I think right now it's I think because we know it's not enough to have international negotiations for the technology transfer, and that's why we are trying to find ways how and what to do to go forward. So thank you for the first directions that you gave us. So.
And also for the future, in case you're coming up with something that is improving the patent that you have now, you know that you can anyway patent that improvement, and the fact that you have already one patent on the base in Georgia does not prevent you from patenting the improvement, for example, in France or other countries within the European Patent Convention boundaries.
Thank you so much. Thank you very much.
Sorry, just to continue your idea that you were just explaining, then what chance does the Georgian scientists have that has only a Georgian patent what should the next step be? Work on the European patent, or can it be in any way enforceable? For example, in other ways, every French company could just check our patent information from someone and just copy it and do it in his own country, and that won't be enforceable. I mean, in that way, I suppose some conventions play roles, or how is it? Sorry for just
Yeah, no.
a little bit deeper.
Because the point is that we need to start from the basic idea that a patent is not a way to exclude the use of the results, but a patent is actually a way to share information, to allow others to know that that something exists and that they can use it as well, or let's say they can know it but not use it. And that is the main principle that I was saying before. So if we can start from this, the fact that there has not been protection in other countries except for Georgia allows the knowledge and the use in this case, but prevents the protection. And so, for example, somebody who is knowing about this and using this information in France will not be able to protect themselves because information is already existing and was patented already in Georgia, and therefore the user, the first patenter in Georgia, is still able and allowed to use it for himself. This territorial principle has its roots in the first Berne Convention that was done under an international point of view, and that is still actually there. And at the time, it could very well happen. There was no internet, there was no interconnection between countries, that there was one invention on one side of the world and another invention on the other side of the world, and that they were very similar, potentially with some intersection with these two patents, but it was ensured for both of them the right of doing their own business, because probably throughout the lifespan of their whole life, they wouldn't have seen each other. Now, of course, this interaction has become much wider, but the principle is actually the same. If you have invented something, but your sphere of interest is Georgia, and at the time you just have that sphere of interest and you didn't expand it or didn't think that it was going to come to France, for example, well, then at the end of the day, given that you have no business in there, why should you prevent somebody from using that information also in there? And I would disagree with the choice of the terminology copy, because patent information is actually to allow somebody to know, and we always give a bad connotation to copying something and so on. I hope it's clear. It's a very theoretical answer, to be honest. We have left the example word and gone towards a more philosophical discussion at the moment.
No, that was very interesting. It's actually quite logical. Probably the scientists and the manager of the idea should evaluate how big of impact this innovation is, and
Definitely.
in that case, it's advisable to have an expense extra to patent it in Europe. Otherwise, but on the other hand, how free are the scientists who publish scientific information in international journals? Would that be also something that could be a security? For example, if he has something published before someone has worked on it, it's automatically it has right, as I remember, first I forgot the terminology, but it has right to have ownership of that idea, as far as I remember. But thank you. It was very interesting and philosophical. That's my last question, and I won't interrupt. Thank you.
Thank you for the question. Very interesting to answer also.
We have left 5 minutes until we should wrap up now, but if I may, I'll ask one final question. Since I'm a legal and financial NCP, it's related to budget. So what should we consider for protecting these results, or whether it's patent or anything else? So what is the like range? How much does it cost to have this European patent? Suppose, is it some fixed like amount,
Yeah.
or
So
it's varies?
you want to talk about money, Shorena, right? You're right. At the end of the day, we always end up talking about money. No, I'm just joking. No, there are some different ways that you can follow in terms of costs regarding European patent protection. On the one hand, there is the protection, the older system that allows you to choose which countries you would like to have your application validated into. Mark the words, because every word is important. So it's just an application validated and granted then by different intellectual property offices in different countries. And that can become very expensive if you choose a lot of country. If you then choose 28 countries, for example, it will become very expensive because you have to pay 28 registration fees in 28 different offices. You have to provide 28 different translations and so on, and it becomes very expensive. If you have 2-3 countries instead, because, for example, we said before, well, I'm going to be needing that in France because I'm going to open up an office in France, then the shipments are going to be done to the Netherlands in Rotterdam, so I'm going to protect the Netherlands. Then my main market is going to be Germany, definitely, so I'm going to protect Germany. If you have only 3, then the costs are lowering down. And here, it depends on the patent attorney you have, of course, because those are other costs, but we are talking about 7,000-8,000 euros, more or less, that you need to take from the budget per patent document in order to be sure. The other choice is the new European patent with unitary effect. So instead of having one application, different countries and validation, you're going to have one application at the European Patent Office that is going to be filed in French, German, or English. And with that one, you're going to have protection if I'm not wrong, 22 different countries, because Spain opted out and the United Kingdom is not in there anymore, and so on. But still large protection with lesser amount of money. I think here I've never used it, but I think we're talking about 5,000 euros, more or less. One interesting tip instead for your budget is that I've seen that happening many times, and it's quite clever, that the coordinator has in its budget the amount that is dedicated to intellectual property and intellectual property rights. But what is interesting is that this amount is shared with the publication cost. So you know that you're going to have application fees for gold open access. So you're going to pay, I think it was around 1,300 euros per application that you're going to have, per publication that you're going to have. So you're going to have many publications, probably. You have 40,000 euros in there. But you dedicate these to intellectual property protection and publication together, so that if you have more IP protection and less publication, then you take the money from the publication and you put it in the IP protection. But if you see that you've got a lot of publications coming up and maybe less intellectual property rights protection, then you take the money from the other pot and you let it down in the publication. In this way, you're pretty much always sure that you've got enough budget to do everything. And that, in my experience, that was the cleverest way I've seen of doing this.
Thank you very much. And yes, in order to be, do we still have time? To be reasonable, we know the cost should be reasonable. So what is appropriate, more appropriate to have, like it should be justified, right? And
Yes.
again, we cannot have, I think, if unless it's necessary for the project, we cannot have this 22 countries or like.
Yes.
What is the ideal like solution in that case?
Yes, so that was the example I was doing in the previous framework. It was before it was possible, reasonable, and justified. Now the rules and the commentaries have changed to possible and justified, but still within justified we have also the costs connected to the different countries where the protection is requested. It depends very much on what you plan to do and what you think you will be doing. Seeking patent protection in Argentina, Uruguay, and other countries of Africa when you know that your invention is going to be only applicable or used in the European Union is something that it is not justified. But at the end of the day, at least in my experience, nobody is going to come after you and say, yeah, why did you protect in Nigeria? It's not justified. That only you are burning your budget. So it's actually in your best interest to be justified, even if actually nobody is going to be the police behind you asking you why you had protected in Tunisia instead of Portugal, for example. But if you go on and select all these countries all together, you're going to spend a very large amount of money, because if you think about it through WIPO, you can have protection in 189 countries. With 189, well, yeah, fees and maybe, I don't know, 50 different languages. It's one whole project budget that you're playing, that you're betting like this, and it's actually in your best interest to try and do the best possible path, and in order to be able to afford further protection in the future eventually.
Thank you. Thanks a lot. And I'm sorry for taking extra minutes from your time. I'm really grateful to Federica, to Michael, for joining us today and giving really very, very interesting presentations and answering so many questions. And yeah, I think we can end here unless there is anyone who still has anything to ask. I will stop recording in case no one has a question. And
thank you everyone for participation, and thank you our colleagues from Brussels for such interesting ideas and information. And see you on the next meeting, on the next info session.
Thank you.
Thank you.
Thank you very much. It was
Thank
a
you very
pleasure.
much. Thank you. Bye.
I hope I received a presentation from Michael and Federica. If you could also send your presentation, I will share with the participants later.
Yeah, of course. Thank you.